do have one question from the audience here. We've got a couple actually, but this one dropped in first. This goes to the whole panel, and it dropped in when we were talking about non-lawyers owning firms. Do you think moving forward, perhaps towards allocating non-lawyers to own law firms, as it may help fund cases against larger corporations?
Well, that was certainly the theory of the law firm that I indicated earlier. Having the ability to have non-lawyers place capital in a law firm will enable a law firm, a small law firm, to be much more competitive. Now, keep in mind the phenomena that has been created in the marketplace, legal funding services, for that very purpose. And so because of the prohibition in Rule 5.4 on non-lawyer ownership, this whole niche business of law firm funding cases, these businesses funding cases, is a phenomena. So I do think one way or another, whether it's through non-lawyer ownership, investing capital, as long as they don't control the operation and tell lawyers what to do, or you'll have some phenomena in the marketplace, such as these legal funding operations.
You know, it seems to me that even a law firm's lender could have influence. So, I mean, I don't know that this would be such a big change as a practical matter. So if a big firm has a line, what do we call them? It's been a while since I've been at a big firm, Abe, but
a line of credit.
A line of credit. Thank you. So, and the bank says, you got to come up, you got to, you know, pay off this line of credit, and it's, you know, a couple $1 million, and the word goes down from firm manager, we got to settle a bunch of cases quick.
Right.
You know, I mean, there's always been that kind of a danger, and we lawyers just have to search ourselves about those things.
Yeah, no, that is true, you know, particularly where you have lines of credit where the individual lawyers, as opposed to the law firm, guarantee the line.
Right, right.
You get a lot of aberrant behavior to avoid circumstances when people depart firms.
Yeah. I mean, personal injury lawyers can be influenced. Well, that's, I was going to say by referral lawyers, but that's, or referral, non-lawyer owned referral services.
Yeah.
So, I mean, we're all susceptible to that in some way or another.
Final question that I want to try and squeeze in. Ellen, it dropped in while you were speaking, but it is open to our panel as a whole. And perhaps the panel could share perhaps one of the trickiest issues or most difficult issues that they've had to deal with within their ethics practice, and maybe a couple of tips on how to best remedy those situations.
So I think one of the thorniest issues that we have to deal with right now, and that's come up in my practice a bit in the past couple of years, is this issue of the unauthorized practice of law. If you work from home in one state, but you're licensed in another state, and you are, working along and think you're perfectly fine because, you're just sitting at home, but you're working on, say, New Jersey cases and you're a New Jersey lawyer. And then what happens is you decide that you're going to try to get a Pennsylvania license. And somebody says, nope, you've been sitting in Pennsylvania practicing law, and that's the unauthorized practice of law. So I really think, I think lawyers have to be very conscious of this. They have to really look at it's Rule 5.5 in your jurisdiction. But I also think that rule has to be changed. And honestly, I look forward to the day when we have this is a whole other webinar, but then when we have a national license. And, I do believe, what do you guys think, Abe and Skip? Do you think that day will come when we have a national license?
Yes, I think eventually you will have some more standardization. For me, the biggest issue we confront and most complex in a big firm with a lot of clients is conflicts of interest. And there are more and more motions to disqualify lawyers or law firms because of prior representations. It's not only a strategic move by some lawyers in cases, but it's a serious concern. The whole concept of screening, and are there ways to get around conflicts of interest? Sure there are. You know, and again, back to my theme of, are we a business or a profession? We clearly have to evaluate the risk analysis when you have a conflict of interest situation. And it's not always a clear analysis under Rule 1.7 where you deal with a concurrent conflict of interest, but you have what I refer to as the New York Times rule. And that is, if you represented a client and then they learn on the front page of the Wall Street or the New York Times that you're representing a competitor, what is the impact of that? It's only a business conflict. How do you deal with it? Should you communicate with a client when you're representing a competitor and it's not a technical conflict? You know, and we could, again, spend the whole program on conflicts of interest, but as firms get bigger and clients multiply, conflicts is a real practical day-to-day problem. Skip?
Yeah, I think conflicts is a big one, even for solo and small firm lawyers. But I think we'll all agree that clients' expectations, especially the less sophisticated clients' expectations, are sometimes unreasonably high. And in this day and age, because of things they see on TV or see on the internet or cocktail party conversation or whatever, and lawyers really need to be careful about managing those expectations.